Hello friends, in the series on the income tax cases, today we will discuss a case in which during the assessment proceedings, the learned assessing officer, on the basis of allegation of incorrectness of the certificate given by the assessee by the civil engineer regarding the work in progress of the assessee, referred the matter to the Department Valuation Officer without rejecting books of accounts. The issue before the tribunal was that whether referring to DVO without rejecting the books of accounts is valid or not. This issue has been taken by Ahmedabad ITAT B bench in the case of Shri Corporation versus Deputy Commissioner of Income Tax, and this matter has been reported in 113 ITR Tribunal short notes 49, and the date of the judgment is 28th June 2024. In the present case, the assessee is a builder and developing the housing projects. The matter is related to the assessment year 13-14 and 14-15. During the assessment proceedings, the assessing officer was of the view that the assessee has suppressed work in progress and the certificate given by the assessee of the civil engineer is not reliable. This was the allegation of the learned assessing officer, and he did not pinpointed the reason for disbelieving the certificate issued by the civil engineer. So the assessing officer straight away referred the matter to the DVO, and the assessing officer did not disbelieve the expenses recorded by the assessee and straight away referred the matter to the DVO. DVO gave its report, and on the basis of that report, the assessing officer issued show cause notice to the assessee, and on the basis of that show cause notice, after receiving the submissions of the assessee and after rejecting the submissions of the assessee, the learned assessing officer made the additions. When this matter was carried to the CIT appeal gave some partial relief to the assessee, and so the assessee was before the tribunal. The assessee main contention was that in the present case, the assessing officer has not rejected the books of accounts, the assessing officer has not disbelieved the expenses recorded into the books of accounts, which undermined the whole basis of invoking the section 144 of the Income Tax Act. The assessee submission was that in the present case, the assessing officer has not brought on record any evidence that the books of accounts of the assessee are incomplete, and the assessee, whatever the submission the assessee has given, the assessing officer has not given any finding on the method of valuation of work in progress submitted by the assessee. When this matter was heard by the tribunal said that in the present case, the learned assessing officer has invoked section 144 and 142A in a proper, not in a proper manner. There is improper application of section 142A because the matter has been referred without rejecting the books of accounts. The assessing officer has not brought on record any evidence that the books were incomplete, or there was not any finding regarding the valuation adopted by the assessee. The tribunal also said that in the present case, the assessing officer only basis of making the addition was the incorrectness of the certificate issued by the government approved valuer. The tribunal said that even if the certificate was incorrect, the assessing officer should have pinpointed the irregularities into the books of accounts and should have referred the matter to the DVO only after rejecting the books of accounts of the assessee. So the procedure of section 142A has not been followed. So whatever the additions have been made on the basis of DVO without rejecting the books of accounts is not as per the provisions of section 142A. At the end of this video, once again I am repeating the name of the case. The name of the case is Shri Corporation versus Deputy Commissioner of Income Tax, and this case has been reported in 113 ITR Tribunal, short notes 49, and the matter has been decided by Ahmedabad ITAT B bench, and the date of the judgment is 28th June 2024. Thank you, friends.